have been a surveyor for 26 years. I say this at the beginning because it is relevant in a way that will become clear, and also because it provides context for everything that follows, specifically the context that when someone builds a fence on my property, I know it, I can prove it, and I am not a person who can be talked out of what I know by someone who is hopping I do not know it. I have spent 26 years measuring land with instruments that are accurate to fractions of an inch. I have set property pins that have stood through 26 years of weather, development, and the particular pressure of neighbors who would prefer the line was somewhere slightly different from where it is. I know what a property line looks like. I know what it means. And I know with professional certainty and personal conviction that a property line means what it says, not approximately what it says, not roughly what it says, but exactly what it says in the specific location where the mathematics and the monuments say it is. My name is Hank Sorrell. I am 54 years old. I live in Birchwood Commons, which is a mid-sized HOA development in Colfax County, Indiana, built in the early 2000s on a former agricultural parcel with the characteristic geometry of developments built on farm ground, square lots, straight lines, uniform setbacks, a predictability that comes from starting with a blank grid and imposing a subdivision plat on it rather than adapting a plat to existing terrain. I bought my house here 14 years ago because the lot backed up to a small natural area, a remnant wetland and upland buffer that the developer had preserved as a HOA common area, and because the lot was a corner, which gave me more total yard than a standard interior lot, and because the price was right for what I was getting. I knew exactly where my property lines were before I made an offer because I pulled the plat and calculated the boundary coordinates the day I looked at the house, which is the thing a surveyor does before he buys property, because not doing so would be professionally embarrassing. The HOA at Birchwood Commons managed the common area behind my lot, the natural buffer area, as part of the development's environmental amenity. It was a nice feature. The buffer was approximately 2 acres of wetland and upland vegetation, preserved by a conservation easement that limited what the HOA could do to it, but permitted maintenance activities, and which gave the homes that backed up to it a view of something other than another house's backyard. The HOA's access to the buffer for maintenance purposes ran through a narrow corridor on the south side of the common area, which connected to a maintenance access road that the developer had included in the original plat. This access corridor was the only way the HOA could get equipment into the buffer area. It was well established, it was platted, and it had been used without incident for the entire time I had lived there. The fence that started this story was built in the spring of my 9th year in the house. I came home on a Wednesday afternoon and found a 2-man crew from a fencing contractor installing a 6-foot wooden privacy fence along what they clearly believed was the rear boundary of the HOA's common area. I stood at the edge of my lot and watched them work for a few minutes, and then I walked over and asked them who had contracted the job. They said the Birchwood Commons HOA. I said I see, and I went inside and got my measuring tape and my survey documents and came back out. The rear boundary of my lot, per the recorded plat, was 132 feet from the rear foundation of my house. I measured from the rear foundation to the point where the crew's fence line was being installed, 126 feet. The fence was being installed 6 feet inside my property line. I walked the full length of the proposed fence run, approximately 90 feet along the back of my lot, and the offset from my actual boundary was consistent. The fence was going in 6 feet inside my property on its entire length. I said to the crew, as calmly and specifically as I could, that I was a licensed land surveyor, that the fence line they were installing was 6 feet inside my property boundary per the recorded plat, and that I was asking them to stop work while I contacted the HOA to clarify the situation. The crew foreman, a reasonable man who clearly did not want to be in the middle of a property dispute, said he would call his boss and confirm the situation before continuing. I thanked him and went inside and called the HOA management company. The management company was Birchwood Property Group, run by a woman named Harriet Vance, who had been managing the Birchwood Commons HOA for 7 years and who I had interacted with twice previously over minor matters that had been resolved without incident. I told Harriet what I had found and described my measurements. She said she would look into it and call me back. She called back 2 hours later and said the HOA's board believed the fence was being installed on the HOA's property, not mine, and that their contractor had measured from the HOA's boundary stakes. I said I was a licensed land surveyor and I had measured from my rear foundation using the recorded plat dimensions, and the fence was 6 feet inside my property line. She said the board would need to review the plat. I said, Harriet, I'd like to be direct about something. I have a professional credential in land measurement. The fence is on my property. I am asking the HOA to halt construction while this is resolved, because if the fence is completed on my property, the cost and complexity of this situation increase significantly. She said she would convey that to the board. The fence was completed the following day. I was at work when it happened. I came home Thursday evening to a 6-foot wooden privacy fence standing 6 feet inside my property line along the full 90-foot rear boundary, separating a 6-foot strip of my yard from the rest of my yard on 3 sides, rear, and the 2 corners where the fence turned to meet the HOA's actual boundary posts. I stood in my backyard and looked at it. The 6-foot strip on my side of the fence was my property. The fence itself was on my property. The entire structure was on my property. I could touch the fence from my yard without entering the HOA common area. The HOA had taken approximately 540 square feet of my yard, a 6 by 90-foot strip, by building a structure that enclosed it as part of their common area. I went inside and called a property attorney named Will Chambers, who had been recommended to me by a colleague and who I reached that evening on his cell phone after I explained that I had a time-sensitive situation. Will said property encroachment cases were not uncommon and asked me to describe what I had. I described it precisely, with measurements and a reference to the plat book and page number. He said, Hank, as a licensed surveyor, you're in a better position than most people to document this. What I need from you is a formal survey, not just field measurements, but a stamped professional survey establishing the true boundary location relative to the fence. I said I could have that done within 3 days. He said get it done and call me. I called my company the next morning and told my office manager I needed a survey crew on my personal property as a priority job. The crew chief, a man named Pete who had worked with me for 12 years, came out Friday afternoon with the total station and the data collector and shot the boundary corners from the existing plat monuments in the subdivision. He located the existing HOA boundary posts, the ones the fencing contractor had used as their reference, and measured them against the plat coordinates. The HOA's posts were 6 feet off, not by accident, not by rounding error, 6 feet, which in survey terms is an enormous discrepancy that does not arise from instrument error or rounding, it arises from using the wrong reference point. Pete generated the formal survey document Friday evening. I had a stamped, sealed survey showing the true boundary location, the fence location, and the 6-foot encroachment across my property by Saturday morning. I sent it to Will Chambers. He called me Saturday afternoon and said, "This is exactly what I needed. The survey is definitive. The encroachment is clear. I'm sending a formal demand letter to the HOA Monday morning." Will's demand letter went out Monday. It was 3 pages. It referenced the plat, the stamped survey, my professional credentials, and the specific section of Indiana property law governing encroachments and the remedies available to affected property owners. It demanded the following: immediate acknowledgement that the fence had been built on my property, a written commitment to remove the fence within 30 days, restoration of any disturbance to my property caused by the fence installation, and reimbursement of my survey costs and a portion of Will's fees. It stated that failure to comply within 30 days would result in a civil action for trespass, ejectment, and damages, and that given the documented nature of the encroachment and the professional survey in hand, we were fully prepared to proceed. The HOA's response came through their own attorney 9 days later. It did not acknowledge the encroachment. It said the HOA disputed my survey's findings and that the HOA's own survey, which they had apparently commissioned in the intervening 9 days, showed the fence to be on the HOA's property. I sent Will a copy of this response and called him. He said, "Hank, I'd like to see their survey." I said so would I. He filed a discovery request with the circuit court, which was the procedural mechanism for obtaining the opposing parties' documents, and we waited. Their survey arrived in discovery. I read it with a professional eye. Their surveyor had used a different beginning reference monument, a point in the subdivision that was not the controlling monument for this boundary under the plat's hierarchy of control, which is a technical issue that a competent surveyor knows how to resolve and an incompetent one might not. Using the secondary monument rather than the controlling monument had produced a 6-foot shift in the boundary location. Exactly the 6-foot shift that placed the fence on the HOA's property in their survey and on my property in mine. I wrote a 4-page technical memorandum for Will explaining the monument hierarchy issue, citing the Indiana survey standards that governed it, and demonstrating that the controlling monument produced my boundary and not theirs. Will filed the 4-page memo with the circuit court as a technical exhibit. He then filed a motion for summary judgment, arguing that the controlling monument question was not genuinely disputed among competent surveyors familiar with Indiana standards, and that the court should rule on the boundary location as a matter of law based on the undisputed plat and the properly applied control. The court scheduled a hearing for 63 days out. 63 days is not a long time in civil litigation. It is, however, a reasonable amount of time to think about the HOA's backyard access situation. I want to explain the access corridor clearly because it is the foundation of what happened next. The HOA's maintenance access corridor, the only way they could get equipment into the buffer common area, ran along the south side of the common area and connected to the maintenance road. The access corridor itself was a 10-foot wide strip of platted HOA property, but its functional utility depended on an approach path that ran along the edge of my corner lot side yard. Not on my property, the approach path was on the platted street right-of-way and the adjacent HOA property boundary. But the turning radius required for the HOA's maintenance equipment to navigate from the maintenance road into the access corridor involved using the open space at the corner of my property as a turning area. The HOA had been doing this for 14 years. There was no recorded easement for this turning movement. There was no agreement. It had simply been happening as things happen in neighborhoods when they are convenient and no one objects. The corner of my lot was open, no fence, no barrier, nothing on the corner, and the maintenance crew used the space to execute the turn that got their equipment into the access corridor. I was aware of this. I had always been aware of it. I had allowed it because it did not inconvenience me and because being a reasonable neighbor is something I value. But I was also aware, as a surveyor, as a property owner, and now as a man who had just had a fence built on his property by the same organization, that the turning movement was a use of my property, or at minimum my property's corner geometry, that had no legal basis in any recorded document. I called Will on a Tuesday evening, 3 weeks after the hearing had been scheduled, and described the access situation. I said I was not asking him whether I could do something physically harmful or drastic. I said I was asking him whether I had the legal right to install a landscape feature in the corner of my lot that would, as a practical matter, eliminate the turning radius available to the HOA's maintenance equipment, thereby making it impossible for them to access their own maintenance corridor with their standard equipment. Will said, "Hank, describe the feature." I said I was thinking about a boulder. Specifically, 3 boulders, set partially in the ground in a triangular arrangement at the corner of my lot, decorative landscape boulders of the kind that many properties in the neighborhood had, serving the dual purpose of marking the corner and providing natural landscaping. Will said, "Are the boulders on your property?" I said yes, entirely within my property line, the surveyed one, not the HOA's version. He said, "Are boulders prohibited by the HOA's covenants?" I said I had read the covenants that week, and they prohibited certain structures, but did not mention natural stone landscape features. He said, "Hank, you have the right to install landscape features on your own property." He paused. "I would encourage you to document the installation thoroughly." I said I would. I ordered 3 boulders from a landscape supply company the next morning. Each was approximately 3 feet in diameter, natural limestone, the kind of substantial rounded fieldstone that sits in yards throughout Indiana's rural areas as a completely unremarkable landscape element. I had them delivered on a Friday afternoon and set by a skid steer operator I hired for 2 hours, 2 of the boulders at the front corner of the side yard, 1 at the inside corner near the property line, arranged in the triangular configuration I had described to Will. I photographed the installation from multiple angles, including photographs showing the boulders' positions relative to my surveyed property pins. I filed the photographs with the date and time in my documentation folder. The boulders were, I should note, genuinely attractive. Limestone fieldstone has a warm color in afternoon light and a natural irregularity of surface that looks intentional without looking designed. My neighbor 2 houses down came over while I was finishing and said, "Hank, those look great. Where'd you get them?" I gave him the supplier's name. He said he had been thinking about doing something similar on his corner. We talked about it for a few minutes. The following week, Birchwood Commons HOA's regular quarterly maintenance run was scheduled for the buffer area. I know this because the HOA sent a courtesy notification letter to all adjacent property owners when they were doing maintenance, as they had done quarterly for 14 years. I checked my cameras on the morning of the maintenance run and watched what happened when the crew arrived at the corner. HOA built a fence on my property, so I legally blocked their only backyard access. The HOA's maintenance crew consisted of 2 men in a utility pickup with a small tow-behind mower on a trailer. They arrived at the maintenance road access point at 9:44 on a Tuesday morning. The maintenance road ended at the approach to the access corridor, where the equipment needed to execute the right-angle turn that got it onto the corridor and into the buffer area. I watched this from my back porch camera footage, which covered the corner area at a sufficient angle to observe what was happening without being close enough to interfere. The driver pulled to the corner and began the turn. The front of the truck cleared the turn. The trailer, the mower trailer, which extended the total vehicle length significantly, did not. The corner where the 2 boulders sat had reduced the available turning geometry by enough that the trailer's path intersected with the boulder positions. The driver tried the turn twice, adjusted his angle, and tried a 3rd time. On the 3rd attempt, he got out of the truck and stood at the corner looking at the boulders and then back at the trailer. He got back in and tried once more. The trailer still would not clear. He parked the truck on the maintenance road and called someone on his cell phone. The call lasted approximately 5 minutes. He and his partner then stood outside the truck discussing something for about 10 minutes. Then they drove away. Harriet Vance called me at 11:32 that morning. She was professionally composed in the way that people are composed when they are calling about something that is not entirely comfortable. She said the maintenance crew had been unable to access the buffer area that morning and that she understood there were some new landscape features at the corner of my property. I said yes. I had installed 3 limestone boulders as a landscape feature on my corner. She said, "Hank, those boulders are blocking our equipment access to the maintenance corridor." I said I was sorry to hear that the equipment was having difficulty and that the boulders were on my property within my surveyed boundary and were a permitted landscape feature under the HOA's covenants. I said I had installed them as a corner accent and to mark the property line, which had recently been subject to some confusion. There was a pause. Harriet said, "Are you aware that the HOA has used that corner for equipment access for 14 years? I said I was aware of that. "Yes," she said, "and you installed boulders there now because of the fence situation?" I said I had installed landscape boulders on my property as a permitted improvement. I said the timing was my own business, and I did not need to explain my landscaping schedule to the HOA. She said, "Hank, we both know what's happening here." I said, "Harriet, what I know is that 3 weeks ago, the HOA built a fence on my property, did not stop when I asked them to, and has been disputing my professional survey in court. I also know that the corner of my property has been used for equipment turning for 14 years without any recorded easement or agreement. I'm not saying those 2 things are connected. I'm saying the boulders are on my property and are a permitted feature, and I'd be happy to discuss any other questions you have." Harriet said, "What would it take to resolve this?" I said I would talk to my attorney. Well, Chambers and I spoke that afternoon. He said, Hank, Harriet calling you is significant. The HOA is not going to be able to maintain their buffer area without that equipment access, and they don't have a legal basis to require you to accommodate it. The boulders have created leverage in the court case. I said that was my assessment too. He said, here's my recommendation. Don't offer to remove the boulders. Let them come to you. When they come to you, and they will, the terms of removing the boulders are simple. They remove the fence from your property, they restore your property to its pre-fence condition, they pay the survey costs and legal fees, and they agree to an annual maintenance easement in a recorded document that gives them the turning access they need, but does it properly, with legal documentation. Give them what they actually need. Get what you actually need. End the litigation. He paused. But let them come to you. They came to me 4 days later, not through their attorney, through Carl Bauer, the HOA board president, who I had met perhaps 5 times in 14 years of living in the development, and who knocked on my front door on a Saturday morning with the demeanor of a man who had lost a vote he had not expected to lose. He said he wanted to talk about both the fence situation and the access situation, and whether there was a way to resolve everything at once. I said I was happy to talk and invited him in. Carl was, I discovered in that conversation, a reasonable man who was embarrassed by the fence situation. He said the board had relied on their contractor's boundary staking and had not done an independent survey before proceeding with the fence. He said when my demand letter arrived with Will's stamped survey, the board had commissioned their own survey in the hope that there was a dispute to be litigated, and that when their survey came back, he had read it alongside mine and had understood, with the help of a cousin who was a civil engineer, that the monument hierarchy issue was real and that my survey was most likely correct. He said getting the board to accept this had taken longer than it should have, and he apologized for that. He said the board was prepared to remove the fence. I said I appreciated that. I said I wanted to talk about the access easement. He said he was aware that the corner access had no legal documentation and that the board understood it should be properly recorded. I said my attorney had drafted proposed easement language and I would share it with the HOA's attorney for review. He said he would recommend the board accept reasonable easement language. I said I thought what Will had drafted was reasonable, and I thought Carl would agree when he read it. Will's proposed easement was 1 page. It granted the HOA a recorded non-exclusive easement for maintenance equipment access over a defined 12-foot turning area at the corner of my lot, limited to maintenance activities for the buffer common area, requiring advance notice of at least 48 hours for scheduled maintenance runs, and including a provision that the HOA maintain the easement area in clean and undisturbed condition after each use. The easement was recorded for the benefit of the HOA's common area parcel and was appurtenant to that parcel, meaning it transferred with ownership of the common area in perpetuity. In exchange, the HOA removed the fence from my property, restored the ground disturbance, paid my survey costs in full, and paid 2/3 of Will's fees. The HOA's attorney reviewed the easement language and proposed 2 minor modifications, both of which Will accepted because they were reasonable. The modified easement was executed 6 weeks after the hearing was originally scheduled. The hearing was vacated by agreement once the settlement was reached. The fence removal crew came the week after the settlement was signed. I watched them pull the fence posts from my property line and carry the panels to their truck. When the last post was out of the ground, I walked to the back of my lot and stood at my actual property line and looked at the buffer area beyond it. My lot was my lot again, all of it, 132 feet from foundation to boundary, unchanged from the day I bought it, unchanged from the day the plat was recorded. The 6-foot strip that had been enclosed behind the HOA's fence was back in my possession, which it had never legally left, possession being different from use, and use having been interrupted for approximately 2 months while a fence stood where a fence had no business standing. I seeded the disturbed area along the fence line with the grass seed mix I used throughout the backyard. I set a sprinkler on it for 3 weeks. By fall, the strip was indistinguishable from the rest of the lawn. The boulders remained at the corner as they had been installed because they were attractive and I had installed them with the intention of keeping them, and because the recorded easement defined the turning area precisely enough that the HOA's equipment could navigate it without difficulty. Pete, my survey crew chief, had staked the easement area dimensions when we recorded it, so there was no ambiguity about where the equipment was authorized to go and where the boulders were relative to that authorization. The boulders are outside the easement area. The equipment turns inside it. Everyone knows exactly where everything is, which is the way property rights are supposed to work. The HOA's quarterly maintenance run happened 6 weeks after the settlement under the new easement. The crew arrived at 48 hours' notice, as the easement required. They executed the turn at the corner, which the defined easement area accommodated without difficulty. They went into the buffer, did their work, and came back out. They left the corner area clean. It took 23 minutes from arrival to departure. Harriet Vance sent me a brief email after the maintenance run. It said, "Hank, the crew said the access worked well. Thank you for the easement. I'm sorry about the fence." I wrote back, "Harriet, glad it worked. Let me know if there are any issues with the access setup." That was the full extent of the post-settlement communication, which I think was about right. The substance had been handled in the legal process. The personal part, the brief acknowledgement of what had happened, and the confirmation that it was over, fit in 2 sentences, which is how it should be. I have thought about this situation many times in the year and a half since it was resolved, in the way that you think about situations that required more effort than they should have. The thing that strikes me most is how unnecessary all of it was. Not the boulders were necessary, because without them, the leverage to reach a reasonable settlement did not exist, and the litigation would have continued on an uncertain schedule at significant cost to both sides. But the fence itself, the 6-foot encroachment into my property, was entirely unnecessary because it was based on a surveying error that a 30-minute conversation with a licensed surveyor before breaking ground would have caught. The HOA built a fence in the wrong place because they trusted their contractor's staking without independent verification, which is the kind of shortcut that works until it doesn't. And when it doesn't, the cost is always higher than the cost of doing it right in the first place. I have built my career on that principle. Measurement first. Verify before you build. Know exactly where the line is before you put anything near it. The line is not a suggestion. The line is a fact recorded in a public document that anyone can pull and anyone can verify, and the cost of verifying it before you act is always, without exception, lower than the cost of discovering you were wrong after you act. Pete asked me a few months after the settlement whether I thought the HOA had known they were on my property when they built the fence. I said I did not think so. I thought they had trusted bad staking and had compounded the error by digging in defensively when challenged rather than doing an independent check and acknowledging the problem. He said, "So it was just a mistake that got handled badly." I said that was my reading. He said, "That's most of them." I said yes, most property disputes are mistakes handled badly rather than deliberate wrongs, and that the handling badly part is where most of the cost comes from. The buffer area behind my lot is green through spring and summer and turns its particular mix of wetland gold in October. I can see it over my back fence, the one on my property line, from the back porch where I have my coffee on the mornings I am home before the day starts. The boulders are visible from the same angle, around the side of the house, sitting at the corner with the comfortable permanence of objects that have found their place and see no reason to move. The stamped survey is in my files. The recorded easement is in the county recorder's office, attached to both parcels. Pete's field notes are in the office archive. The documentation is complete, organized, and retrievable by anyone who needs it. That is ultimately what I do. I measure things, I record what I find. I put the documentation where it can be found. And when someone builds something in the wrong place, whether from error or from the comfortable assumption that no one is paying close enough attention to know the difference, I know the difference, and I have the instruments and the credentials and the professional obligation to say so, clearly and with evidence, until the thing in the wrong place is in the right place or gone. The line is where the line is. It has always been there. I just know how to find it. Thumbnail text, **. They fenced my land. I blocked their only way in.